Williams, and today is September the 19th of 2024. I'm going to call the entire calendar to ascertain where we stand today. And I'm going to ask the parties to attempt to pre-try the matters one last time before we begin any motions hearings. All right, I'm going to call the first position, 21 CR 0000837G, the case of Jermaine Lee.
Yes.
Good morning. Good morning.
Evan Watson for this week's press, ready?
And good morning, Judge. I did attempt to pre-try that yesterday evening with Mr. Watson. I sent over an email.
Microphone, please.
Oh, I apologize. With regard to that particular case, if we're not able to work it out this morning, the officers are coming from Forsyth and Roswell. And so I would just ask that we be able to hold for them, if possible. They're coming.
Let me talk with Ms. Walter. She is correct. She reached out. I got out of it. We got a jury verdict about 6-something PM. And I just talked to Mr. Lee literally 20 minutes ago.
Well, I'm gonna hope that we all can do that and aren't holding for people coming from Forsyth. All right.
I'm gonna have a quick conversation with everybody.
All right, sounds good. Let's hold. Oh, thank you. Just hold 1 second. Let me continue with the calendar, see who else is here. All right, we'll pre-try that. And Mr. Lee, you can have a seat. And I apologize. I know I'm not gonna get this next name correct. This is 20 CR 002789G. The case of Shamini Manjor Rundithon. I'm sorry if I'm saying it incorrectly. And I see that this case has been continued. Is that correct?
I don't know, Judge. I filed a motion for continuance.
Is
so I
the
don't know.
defendant here?
I don't think she's
I
here
don't
yet,
think
but she
so
may be on the
either.
way with Mr. Shaw. I don't know. I didn't get a response to my motion.
Okay,
But that was the state's request, yes.
okay, so we'll hold for that one.
Okay.
21 CR 004148G, the case of Brian Ramirez. Is anyone here for Mr. Ramirez?
Now, that one, I did get an email that it was.
Oh, a conflict, I see
correct.
it. So that one is reset. All right, thank you.
Mhm.
21 CR 006548G, the case of Hee Young Shin. The announcement for that one?
Morning, Judge.
Morning.
We had submitted for kind of late yesterday, from Ms. Smith, motion for continuance on that.
Oh, okay, I didn't see
It
that.
was after 4:30, so it was probably.
I was gone, yeah.
Yeah.
Okay, I'll take a look at that. Why are we continuing, counsel?
Well, she's out of town, Judge, and then also, I had spoken to Mr. Birch about that, and the state consented to the continuance.
Okay, well, so reset then, thank you. Mr. Stein, any objection? Mr. Birch isn't here. I doubt that you object, Ms. Waldrop. Okay, we'll continue that case. I don't have a,
Birch, no objection.
yeah, okay, I don't have a date that we're resetting it to, so just reset for the notice, all right?
Does that go back to the original?
Probably, more than likely.
Not, it is a return to the notice pending motion.
Oh, all right, yeah. No reset, it's return to division.
It'll be returned to division.
It'll go back to the original division.
Yes.
Okay, so just wait for notice. Thank you.
Take care. Have a good afternoon. Sorry you had to come for
Oh,
that.
that's okay, Judge. We submitted it late, so.
No one looked at it yet, not one person. Okay. Take care. All right, 22 CR 009305F, the case of Rahuma Antenu. And I see that that one's reset. No,
That's my understanding.
leave of absence filed for that one. So we're only holding on this one position.
Yes, Judge, and I will go speak with Mr. Watson.
All right, wonderful. And I'm hoping, Ms. Waldrop, that you'll really dig deep and you all will be able to come up with something to resolve this matter today.
Yes, dug deep, Judge.
I believe. Where's Mr. Watson? Mr. Watson, dig deep as well. We'll be on a brief hold.
Unfortunately, defense has rejected the state's offer of a reduction, so I'm just gonna try to get an ETA for both
Oh
officers.
my gracious, we couldn't figure this out?
We couldn't.
What
Judge.
the-
Actually, we made a counteroffer, Your Honor. I want to put that, like, to your knowledge, we have made a counteroffer. The state has likewise rejected the counteroffer. So
Okay,
where we're at.
can I hear the defendant's history and can I also hear the offer and counteroffer?
Yes, Judge, just one moment, let me. pull
Because
up the
perhaps we
history.
could do some type of non-negotiated plea
Well, I think they're
situation.
not inclined to plead to the charge of reckless, so I think that's the issue.
Cause I mean, waiting for somebody from Forsyth and we're gonna be here till 3 o'clock.
I don't know if it'll take that long, Judge, but I just would ask that
In
we.
my estimate,
Southbound, because
And
that's where my
it's a-
office is. They're holding on my report. We go northbound is normally easier.
okay, well.
And Judge, just for the court's notice, I put them on call because a conflict had previously been filed, and so that's why they were holding. They
Okay,
are under subpoena and they are prepared to come. I'll get you the history, Judge.
okay, thank you, Ms. Waldron.
Your Honor, so I show, 4 cycles of arrests, Judge. I show a 2008 battery family violence that was amended to disorderly conduct. There was 2 counts on which he was convicted. I show a arrest for unauthorized discharge of firearms within 50 yards of a public highway.
Mhm.
And then a later arrest for carrying a pistol without a license. With regard to driver's history, Judge,
This is the first DUI?
I don't see a prior DUI, Judge.
Okay,
With respect to driver's history, I show a 2011 speeding, 81 and a 60. I show a another 2011 speeding, and that was 80 and a 55, Judge. And in this particular case, similarly, he was going 85 and a 65. With respect to the state's offer, it was to dismiss the DUI less safe, to reduce or amend the DUI per se to reckless driving with the standard first terms in terms of a DUI statutory minimum terms. And then on the speeding, it was a fine of $500.
okay. And Mr. Watson, what was the counter?
Your Honor, first of all, my client contests and does not agree or otherwise represent that that is his correct or that is his GCIC. And as you know, in misdemeanor discovery, I've not had access and nor do I to that. So I'd like to confer with Ms. Walter if that becomes relevant about whether he has any history or not. But I will say, Your Honor, based on the age of this case, as well as I did file within the past 2 weeks, probably right around well, it may have been beginning of last week, I did file an amended motion to suppress that more specifically laid out for the court all of the issue in this case. So we do feel very strongly that there's a constitutional deficiency in the state's case. The counteroffer was that he would plead guilty to the speeding, which was originally just going to be a warning issue to him. That becomes somewhat relevant, but he would plead guilty to that charge, pay a fine in the state's or the court's discretion, and he's already done a 20-hour risk reduction panel. He would turn that in as part of this, as you know, that's geared towards alcohol awareness, especially as it relates to the operation of motor vehicles. So that was our counteroffer. Given where we stand, we feel that we have strong issues in this case to challenge, so.
Okay, so but that we were unwilling to plead to anything more than the speeding, correct?
stated about the to speeding citation with terms, with those terms.
And that's the only charge he's wanting to plead to is speeding? I just want to confirm that.
Yes, yes.
Okay. All right, sounds like we're at an impasse. And Ms. Waldrop, what is the ETA for your witnesses?
That's what I was just gonna reach out and try to get
Okay.
that, Judge. Mr. Shaw is present on position number 2, Judge.
Good morning, Your Honor.
Okay, good morning.
Your Honor, Miss Manoranjan texted me informing me that she's stuck in traffic.
The state has filed a motion for continuance of this case. Do you object to that continuance,
I have an
Vivic?
objection to that on the ground, Judge.
Okay,
I can step outside and just call them.
all right, and in the meantime, will you attempt to pre-try this matter as well?
Sure, Judge.
All right. Can you print me Essence, the suppression motion? Sounds like we're gonna do this.
For position 2?
One, or both, actually, I guess. It sounds like we're doing both.
Yeah, so we're good. Good morning.
Good morning, Mr. Burge.
Oh, that's being later.
That's right. Happens to the best of us.
Report.
Okay, I'll grab that.
I was like, cause I know it's coming.
I think it is. Replaying a video.
Well, I used to work in Fulton. Now they work in Portsmouth.
Oh, you called it in. Okay.
This is the first day live.
I'm trying to tell the print and. It's on, but going into, to keep it from printing on both sides. There's no preview.
Right, because what is doing, like, I went upstairs yesterday. The printer went down, it's like the internet or whatever, so the printers went down. And that's why it took so long, and that's all.
What, you got USB?
Right, wait.
Got USB, Miss, sure.
I don't, I just gave them the card.
I got USB. If you wanna save it to USB in your printer like that.
Oh, yeah, I could do that, but
You got your,
I gotta jump.
That jump drive? Okay. Yeah.
Thank you for going through such effort to print that for me.
Yeah.
Hmm. Oh, man, I don't understand what I did wrong. Thank you.
It says nothing. That's what you know, earlier. It's been known to win. It has, hasn't been. At least they keep on doing it. Not this one. Sit here and do it my other work. I put it out, second, the other motion, for now on this. That's one. You just want that one secret, that's emotion to suppress, so you don't have to constantly, like.
How many are there? I don't mean to make you print them all. I just. Is there a whole lot? Let me see if I can log in myself and read them. Thank you.
You know, for now, you want position one, because that's position two. I'm saying on this list, put it on this motion. Yeah, I'm not doing that. Well, that's all they're doing. That's not ready for her, but position one. They have a motions package back in 2021.
No, don't print. I'll just log on.
That's for the first one. Let me go.
Yes, I'll put it now.
Of course, I'm gonna say, how they, six deputy work.
On this, amended.
So they got motions for continue, and motion for judicial notice. So we just start with. First, 2023. 2021, that's what it was supposed to be covered. So that's like four, where the second,
The second one, I'm not that worried about yet.
okay,
The first one, I just needed. How many was there for the first? You said there was
this one,
just the suppression. Okay.
yes, and but did have one later in 2021.
The state filing.
the motions packet 2021.
I'll look online. I'll read it out for you. That's okay.
It's about,
Let's hope actually works.
it's more than 15.
Okay, I'm sorry. The announcement for position 2, is there one?
We have a plea for your consideration this morning.
Okay,
That's right.
all right. Is, I'm sorry, please pronounce your client's last name. I don't want to miss them.
Manoranjan,
Ms. Manoranjan, please come over to the podium.
Judge, we just have to complete the paperwork.
That's fine. She can sit there and just wait for a moment. Mhm.
Thank you, Your Honor.
When she needs to do the paperwork though, so you guys can sit wherever you feel comfortable to do that, all right? And when she's ready, just have a seat over here at the podium.
Yes.
Thank you. All right, we're gonna now take up position 20 CR 002789G, in which defendant was originally charged with DUI per se, reckless driving, and DUI less safe, with the offense date of September the 1st of 2018. Ms. Waldrop, if you put the recommendation onto the record for me.
Yes, Judge, the defendant is pleading to one count of reckless driving. We did-
Microphone, please.
Yes, Judge, the defendant is pleading to one count of reckless driving. And the negotiated sentence is for 12 months, credit for time served of 1 day with the balance on probation, to pay a $400 fine, complete an alcohol and drug evaluation and any treatment deemed necessary, as well as a victim impact panel and risk reduction. We did agree that it could terminate upon successful completion. This is the only thing that I see on her GCIC.
All right, counsel, do you stipulate to the 3 elements, and was that your understanding of the offer?
Yes, Judge.
All right,
That
thank
is.
you. All right, please raise your right hand, ma'am. I'm gonna ask some questions to make sure this is a voluntary plea, all right? Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you satisfied with your attorney's representation today?
Yes, ma'am.
Did anyone force you to plead guilty?
No,
Did anyone promise you anything in exchange for pleading guilty?
no.
And you understand you're giving up your right to trial by judge or jury by pleading guilty today?
Yes, ma'am.
And do you fully understand the requirements as explained to you by your attorney?
Yes.
And, let's see, make sure, oh, and you understand that pleading guilty may affect other aspects of your life that we might not be able to anticipate, such as employment, probation, immigration, and anything of that nature?
Yes.
All right, as to the charge of reckless driving, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional, Ms. Waldrop or counsel? Anything additional?
Further from the state judge.
Just that, Judge, you accept this, or you have accepted this plea. I just want to share a little bit about Miss Manoranjithan. Your Honor, I met her in 2018 with her father and her sister when they learned about this case. Throughout my representation of this case, Judge, they've been extremely serious about this matter. Miss Manoranjan has been admitted into medical school since this incident. She's been flying down to the state of Georgia and to this and to Atlanta every time we have this court hearing, Judge. And she's obviously taken this matter extremely seriously and doesn't expect to repeat any such offense. So thank you, Your Honor, for taking this plea.
Thank you as well for that information. In light of that, and I know this may not be something you have discussed, would the state object to her taking a no-low plea? And does she want to use a no-low?
You want to? Just if I could have a quick. If I could have a
If the
quick
state,
moment.
Ms. Walker, you can put any objection onto the record.
And Judge, that was not a part of our negotiations. so
Clearly not, because I'm asking
Right,
it,
so,
but I'm asking the state to lodge any objections at this time.
it wasn't a part of our negotiations, but I will say I don't see a driver's history and I don't see any prior criminal history.
Okay,
So she is eligible.
okay.
It'll be for counts 1. Well, yeah, I guess I'll do it for 1 and 3 since she's charged with the reckless. I thought I was gonna have to amend it, but
No, because that's where I was getting confused and I was like, let me get clarification. If you're gonna amend one of the DUIs and
I
then
will.
no crossing.
I'll do this. I'll do the no cost for the 1 and 3.
So no amended. For the record, right?
All right,
She does wish to invoke.
and the court will allow it and the state's objection is noted. We're just gonna have you change this in this paperwork.
Yes, Judge.
So as to the charge of reckless driving, how do you plead?
No low contender.
NOLA.
All right, I accept your no low plea at this time. We can just, it's not really circled, so she can just fully circle no low on the paper.
Yes, Your Honor.
All right. Best of luck to you, ma'am.
Thank you, Your Honor.
All right.
That's it. Thank you, Judge.
All
Pleasure
right.
being before you, Your Honor.
All right, take care. Have a good afternoon.
Just tell them on social. Is that all you need?
That's good enough. As long as it's clear that it's a no vote, please.
It's-
Your Honor, if I may address one more item,
Yes,
that again, it was sort of implied to Ms. Waltrop, but wasn't expressly agreed upon. Ms. Manoranjan flies in here, and she lives in Wisconsin at the moment, I'm sorry, Missouri, where she goes to medical school. Would the state and the court be amenable to reporting by phone or mail? I mean, that's only until the point where she completes the conditions anyway.
I don't have a problem with that. Ms. Waldrop, any
I
objection
don't
from the
think that,
state?
yeah, I don't have a problem with that.
That's fine.
Yes, Your Honor. Thank you.
I think they'll let her report by Zoom, I think is what happens.
Oh, I see. Okay.
That's fine.
Yes, Judge.
Credit the concern.
I didn't write anything, but she is supposed to get credit for one day.
And Judge, just a quick update on Sergeant Burnett.
Okay.
He was in court in Forsyth, so I'm trying to get that ETA for you.
I have a question, but I'll wait for Mr. Watson's return.
Okay.
But if the answer to those is no, but I'm asking you at least to discuss it.
We are still at, excuse me, let me turn on the mic. I believe that we are still at an impasse at this time.
Okay,
I did want to provide the court with a few updates.
okay.
Judge, so first and foremost, defense counsel filed a leave of absence, indicating that he would be in Forsyth County this morning, listing several cases on which he would be there for. And so for those reasons, we placed our officers on call. And it's my understanding that one of the officers that I have on call right now, Sergeant Burnett, is in Forsyth County with
So
defense
he's not
counsel's
coming.
law partner. No, he is prepared. He's on call, Judge. So he is prepared to
Mhm.
come. It's just that he's on call. With coincidentally or not, defense
Can he
counsel,
log on Zoom?
I don't know if he can log on Zoom.
Can we ask that?
I can reach out to him and
Let's
ask that.
try
Judge.
that,
But
cause
he's in Forsyth County with the defense counsel's law partner on a case. I also want to point out to the court, because I heard defense counsel say that he had filed a motion, I guess, a few days back. That is not the motion, Your Honor, that the state was under the impression that we would be going forward on. So there was a motion in limine that was filed, it looks like as part of a packet back in 2021, December of 2021.
I see that packet,
Right.
so you
So-
thought we were doing those
And
and,
that's why I called Officer Brake and Sergeant Burnett. But if there is a motion, an amended motion now that has been filed, that was filed after we had already,
okay.
identified the witnesses in this case, then I'm going to ask for a reset because this motion is untimely. And so if the state needs to go forward on an amended motion, then that's not what we're prepared to go forward on today.
Let me go back, let's start at the beginning. You hit me with a lot, Ms. Waldrop.
I
Let's
know.
see. The first thing was, let's look at this conflict notice.
Yes.
Let's first go there. And Odyssey is very slow. Bear with me, Ms. Waldrop, Mr. Watts. We are very close to resolving this. And I mean, I know my role today is not mediation. However, I'm not, Ms. Waldrop, I'll say to you, I'm not hearing a whole lot of driving DUI related history. And Mr. Watson, I'm saying to you, there are some things that I'm reading here that might consider that your client may not want to go forward with this. You all really weren't able to do anything additional with this?
Your Honor, we've offered to dismiss the DUI charge.
I mean, but you know, okay.
Your Honor, I don't wanna, I would like to turn to speak. when the court-
Go ahead, go ahead. Wait a minute, one second. What date is the conflict notice, Ms. Waldrop, that, or Mr. Watson, what was it, what day was that?
I don't, we all.
Oh, okay, I see it. I have conflicts for the week of September 16th in cases I've listed in order. I will make an appearance. Okay, so he said I may come pretty much. He didn't say I'm not coming. He said I'm going to do my best. Okay, okay, so that was the first thing you hit me with. Let me pull up the second thing.
May I address that very quickly?
Sure, good. But I think I get it, Mr. Watson, and it's the standard conflict we all file. I'm trying to come. I have court Monday, and if it doesn't bleed over, I'll be here.
But I guess the part I'm confused about Ms. Waldrop's representation.
He's not at the microphone, Judge.
Oh, come forward to the mic so the court reporter can hear you.
I guess the only part I point out to the court is that Ms. Smith, Ms. Essence Smith had sent this chain out last night, yesterday at 4:50 PM, inquiring into my conflict and whether my appearance was likely or not. By 6, my final reply in that thread to all, including Ms. Waldrop, at 6:19 was, my conflict has resolved. I will see y'all in the morning. I don't know how that's unambiguous, or maybe I'll be there, maybe I won't. So, my client's been waiting years and years. So I thought, CC everyone into this, process here that I'll be here for it. So there is that. And then I know
Okay.
you're reviewing part 2.
Part 2. Let me pull part 2. Ms. Waldrop, you wanted to add something? Okay, you already said it's untimely. Mr. Watson, your response to that while I try to get it to
Well,
open?
it's not untimely, it's that you can, I mean, unless Ms. Waldrop has a case to suggest otherwise, I can modify, amend. My original conflict actually adequately preserves the issue we're here to argue, which is that the detention of the defendant was unreasonable. But in an effort to further particularize it so that our judge, a lot of judges like to, hey, let's trim the fat, let's get to it. So it's been further particularized, and that was actually served on the prosecutor.
Right, and there's also a
We
motion
had a
reserving the
different point of
right.
contact, but I believe the whole solicitor's office is presumed to have knowledge of filings that are filed. So it's timely. It's just further honing in on what the real issue is here. And
I'm
it's-
inclined to agree because I'm reading that and I just read the amended. It doesn't add significantly or very far off from the original packet, but I will look at it more closely. I'm gonna look at it now. Ms. Waldrop, will you see if you can get your witnesses on Zoom?
Sure, Judge.
Because we could, they don't have to come, they just have to come. Any news on his report via Zoom?
Judge, so he is in Forsyth Court. He can be on Zoom afterwards. And I sent the Zoom link to my investigator who's gonna get it over to.
Okay. We're gonna get started at about 11:15. All right?
And Judge,
Yes.
I don't know what kind of hearing it is, so I don't know if he'll be
Well,
available.
we're gonna have to get started. We can't wait on him indefinitely, especially when he's under subpoena to be here today, okay?
He's also under subpoena on another case in Forsyth.
I understand, but we're gonna start at 11:15 with or without that gentleman, okay?
Okay. And if the court will allow, can I go ahead and make a motion now?
Well, Mr. Watson's not here, so let's do that.
I thought that he was here. I thought that's why we were discussing it. Okay.
Mr. Watson's back. Go ahead, I was indicating that we're gonna start at about 11:15 with or without this gentleman, and hopefully he'll be able to arrive by then. Go ahead with your motion, Ms. Waldrop.
Yes, Judge. So the officer has another subpoena that he is under. He is currently in Forsyth County Court on that subpoena. And so for that reason, I will go ahead and motion for continuance so that I don't waste any more of the court's time. I can certainly get you a copy of his subpoena for the case that he's in Forsyth County on. But I don't wish to waste any more of the court's time. And so I would ask that the case be reset so that officer can obviously not have any other conflicts.
We're all here, Ms. Waldrop, and we're ready, so let's see what we can do. And like I said, I'm gonna give him another 30 minutes to appear either Zoom or by phone or something, okay? We're moving forward. And is it two officers under subpoena or just one?
It's two officers, Judge.
And both of them, neither one of them is available to come now?
The other one was on a call. He works nights, Judge. So
Is he coming?
yes, Judge, yeah. Our intention is for both to be here. I have sent the Zoom link. And so that both of them can hopefully be on the Zoom.
Okay.
My motion, Your Honor, just for the court's edification, motion primarily involved officer one, not two. So this Burnett guy, this other Versailles, is not really a pivotal part of this from the defense perspective.
Well, and the gentleman that's on call that works nights, is he on the way? Have we spoken with him? What is his status?
I will get in touch with my investigator to see if he was able to make contact. I find it interesting that he's saying that it's officer number one when his motion challenges other things. So unless he is going to waive the other issues brought up in his motion, because Sergeant Burnett was the one that did the fields.
Well, from the court's perspective, nobody's here. So I'm trying to figure out, are they coming or what are we doing?
Yes, Judge.
All right, let's figure that out.
My message there, okay.
Be looking for the signature for the two walls up on that mailbox.
I'm sorry, was that again?
Position two. I went ahead and did it for you.
Okay,
I just need that signature so I don't have to close this case out.
okay.
Unless it's not sufficient. She can- Oh, yeah, she's okay with it.
Yeah, she signed it for you. Thank you.
Thanks, I can help sometimes.
I appreciate it.
Thank you. Yes. All right, good afternoon. Well, it's still morning. Good morning, everyone. We are now going to commence the hearing in the case of State of Georgia versus Jermaine Lee 21 CR 008373. 00837G. We're here on defenseless motions. So we'll allow Mr. Watson.
Well, Your Honor, I believe we need to at least make an announcement. Sergeant Burnett is online. He is actually in the process of a hearing in Forsyth County. He's about to give testimony, so I just want to let you know. So if he can go do his hearing and we can start with Officer Brake, that's fine. But he's being called to the stand.
Okay.
Sergeant Burnett, can you please explain to the court?
He can't hear us. You're muted. We can't hear you.
Can you hear me?
All right, we understand. We'll allow Officer Burnett to go first, but let's let Mr. Watson make the substance or an opening since we're hearing your motion, correct? We'll let Ms. Waldrop make a response and then we'll take whatever testimony we need to take quickly from Officer Burnett. All right? Does that work? Does that work for all?
I believe it's Officer Brake.
I'm sorry, Officer Brake is the one who's going on. Is that correct? Is Officer Brake frozen? Officer Brake, can you hear us? You're
Yes,
about to
ma'am.
go
Yep.
give testimony shortly?
Yes, ma'am. I'm here.
All right, we're gonna, you're about to go onto this witness stand shortly?
No,
Your Honor, that's me, Sergeant Burnett.
Okay, go ahead. What would you like to tell me?
That's what I was about to tell you. The state and the defense are currently sitting at their tables waiting for me to go give testimony. So if I could be excused until I conclude this hearing.
Do you know about how long you'll be? You don't have an idea. All right, very
Yes,
briefly. All right, that's fine. Go ahead and do that. Go ahead and give that testimony, okay?
Okay.
All right. We're gonna commence the hearing and start, and hopefully Officer Burnett will be back, but we're not gonna hold this all day for this, okay? All right, and you can object to that later, Ms. Waldrop. I'm sure you object, but of course, we will consider that. Okay, Mr. Watson, any opening? Please proceed.
Your Honor, does the court have you want a hard copy or do you have?
I have a hard copy. I do.
Okay.
His mic is not good.
You know what, because I'm not talking.
Turn it on, make sure it's red, it's not red,
Red hot.
green, make it green, there you go,
Now it's on.
yeah.
Can y'all hear me?
Thank you.
Yes, of course. Yes, ma'am, Ms. Carter. We are here today, Your Honor, because as I filed in my amended motion to suppress, of course, we would adopt and incorporate my prior motion in this grounds. But if there's one issue I would appreciate the court paying attention to this morning above all else would be the delay here. The delay. Officer Brake, who I anticipate the court with her testimony from, was perfectly qualified on the evening in question to conduct standardized field sobriety testing and pursue diligently a DUI investigation. I believe the testimony to show Officer Brake likewise had a backup officer with him, which could potentially go to some officer safety concern, but he did not choose to do that. Rather, he radioed and called a second officer. So at the conclusion of the evidence that bears out, and then based on case law that we'll present, we'd ask that you suppress this interaction and this detention of my client. Thank you, Judge.
Okay, Ms. Waldrop?
Can somebody swear Officer Brake in, please?
Raise your right hand. Do you swear affirming testimony to give today is the truth, the whole truth, and nothing but truth to help you?
I do.
Can you state your name for the record and the agency that you're currently with?
My name is Omar Brake, OMARBRAIK, and I am a sergeant with the Roswell Police Department.
Good morning, Officer Brake. Thank you for being here. How long have you been employed?
Microphone, Angela.
It's on. How long have you been employed with the Roswell Police Department?
6 years, about 6.5.
Okay. And prior to the Roswell Police Department, were you employed with any other agency?
No, ma'am.
Okay. So 6 years total in law enforcement, is that correct?
Correct.
Okay. And are you post-certified?
I am.
Okay. And as part of your duties with the Roswell Police Department, can you tell the court about what it is that you do on a daily basis?
Currently, I'm assigned to uniform patrol as a patrol sergeant. I assist with calls for service, as well as conduct traffic stops, and patrol the city of Roswell.
Okay, and back on 2020, what specifically was your title?
I was a patrol officer, so I responded to calls for service, conducted traffic stops, patrolled the city.
Okay. And can you tell the court a little bit about your training as a Roswell Police Department officer?
I've
And
been,
specifically, I'm speaking of your training back in 2020.
I had been to speed detection as well as standardized field sobriety.
Okay. So you had only done the standardized field sobriety as part of any DUI training? Is that correct?
I
At that
believe
time?
so. I don't remember if I had a ride, or I don't recall if I had a ride at the time or not.
Okay. And those standardized field sobriety, what test specifically were you trained on?
The horizontal gaze nystagmus, the walk and turn, and the one leg stand.
Okay, and at that time in 2020, July 30th of 2020, how long had you, where had you been trained on that?
At Gypstick.
Okay, and how long was that training?
I think it's a 3-day class. It's either 3 days or a week class.
Okay. Is that a basic class and not an advanced class?
Correct.
Okay. And during your training, were there certain standards that you had to meet in order to become certified in those fields?
Yes, there were.
Okay, and did you meet those enough to pass?
Yes.
Okay, all right. And up until July 30th of 2020, how many DUI investigations had you conducted?
I don't recall.
Okay. Do you recall approximately how many you've done in your career?
I don't.
Okay. Okay, now you were working as a Roswell police officer on July 30th of 2020, correct?
Yes.
Okay. And on that particular day, were you in full uniform to include your badge?
Yes,
Okay. And were you in a marked patrol vehicle?
I was.
Okay. And you stated that you were a patrol officer at that time. Were you on patrol the night of July 30th, 2020?
Yes, correct.
Okay, specifically what area?
I was running speed detection on Georgia 400 northbound.
Okay. And can you tell the court about kind of what it is that you do when you're running speed detection?
I observed vehicles that appear to be traveling at a high rate of speed. I then use my city issued laser to confirm or to gain the actual speed of the vehicle.
Okay. And are there times when you may not use a laser or type of device?
Yes, you can pace the vehicles as well, and visually estimate their speed.
Okay. And when you were patrolling on July 30th, 2020, did you state what area you were in again?
I was on Georgia 400 northbound, I believe I was just north of Holcomb Bridge Road.
Okay. And is that in Fulton County?
It is.
Okay. And did you have the opportunity to come into contact with a white sedan?
I did.
Okay. And how is it that you came into contact?
I observed the white sedan traveling at a high rate of speed. I used my Pro Laser 3 to obtain the actual speed at 85 miles an hour in a 65-mile-per-hour zone.
Okay. And what did you do next?
I conducted a traffic stop. It was just north of Mansell Road at
Okay.
that
And
point.
is just north of Mansell Road, is that also in Fulton County?
It is.
Okay. And what did you do next?
Made contact with the driver and the passenger, identified myself, and asked them where they were coming from. They advised they were coming from Buckhead. which is a well-known bar district.
Okay.
I asked if they had been drinking, and he said that they had just been hanging out.
Okay. And who did you identify the driver as?
Jermaine Lee.
Okay. And what did you do after you had asked them about what they had to drink? What occurred next?
I went back to my patrol car and ran both of their informations. When I approached the car the first time, I made a passenger side approach because it was on Georgia 400 northbound. So I don't like making a driver's side approach with my back to traffic.
Okay. And when you encountered the driver, did you, although you encountered him from the passenger side, did you advise him of the reason for the stop?
I did.
Okay. And did you ask for his license and registration and identification information?
Correct.
Okay. Now, when you approached from the passenger side, did you notice anything did you make anything of note to yourself with regard to your contact or encounter with the individuals within the vehicle?
When I made the passenger side approach, no, I did not.
Okay, so tell the court what you did when you went back to your vehicle.
So I entered both of their informations in the GCIC and NCIC, but the passenger's information was out of New York and the state line was down. I did get the return from Lee, which didn't have any warrants and his license was valid.
Okay, and Lee was the driver, correct?
Correct.
Okay, and so what did you do next after you ran his information and found that it was valid?
I used officer discretion to issue a warning for
Okay.
speeding.
Okay, and what did you do next?
And then went and made contact. I had a second officer with me at the time, so she approached on the passenger side, so therefore I approached on the driver's side. And then go ahead.
I'm sorry, the second officer, at what point did you call out the second officer?
A lot of times when we do traffic stops on 400, there's just another officer that shows up, especially once, because Mansell Road leads out of the city. So especially at that point, there's usually just a second officer that comes.
Okay, so that second officer would not have necessarily been called out by you, but just arrived on scene. How would they have been notified to do so?
Just through radio.
Okay. So not through you.
I don't recall whether or not I called for her.
Okay.
Highly doubtful in this
Okay.
situation.
Okay. And this was back in 2020. Have you done numerous stops since this date?
Correct. I've had a lot of stuff that happened since this date.
Okay. That's all right. Okay, so you went back and you reapproached, did you say from a different side of the vehicle this time?
Correct.
Okay, and what did you, I guess, describe your encounter at that point with the driver?
So I was explaining to him that I was just giving him a warning for speeding. And I noticed that he had bloodshot, watery eyes, as well as the odor of an alcoholic beverage emitting from his breath.
Okay. Did you ask him anything else at that point?
I asked him if he had anything to drink, which time that he stated he had one Corona.
Okay. And at that point, what did you do?
I asked him to exit the vehicle and I requested Officer Burnett, who's a DRE, which is a drug recognition expert, to be en route to the location to determine if Lee was safe to drive.
Okay. And when you asked the driver to then exit the vehicle, did he comply?
He did.
Okay. And when you called out, you said that at the time, Officer Burnett was a DRE, is that correct?
I don't know if he had his DRE certification at that point in time,
Okay.
but he was very much into DUIs and he wanted all of the DUIs that he could get. I mean, it was just his passion.
Okay. And so is it accurate to say that Sergeant Burnett, now Officer Burnett back then, was more experienced with DUIs than you were?
Absolutely.
Okay. And would you say significantly more experienced?
Yes.
Okay. And so at what point did Officer Burnett arrive?
I don't know time frames. I don't know. I don't recall.
Um, did it, to your recollection, did it appear to be a lengthy amount of time that it took?
I couldn't.
I'm gonna object, Your Honor. That calls for speculation.
I'll let him answer the question.
I don't recall. I couldn't say.
Okay. Had it taken an inordinate amount of time, what would you have done?
Let him go. It's
Okay.
I mean, you could get just about anywhere in the city of Roswell at 3 a.m. very quickly.
Okay. One moment. Had it been an inordinate amount of time that it had taken for Officer Burnett to arrive, would you have noted that in your report?
Yes,
And would you have noted that you let the defendant go had that occurred?
correct. I wouldn't have let him drive, but I would have had him come get a ride
Okay.
if it would have been too long of a period of time.
Okay. And as far as the defendant's demeanor, can you describe that to the court?
I don't recall.
Okay. Would you, would it be accurate to say he was compliant?
Correct. I mean, he got out of the car when I asked him, so
Okay.
he didn't push back or anything like that.
Okay, and when you asked him questions during your stop investigation, was he responsive?
I don't recall.
Okay. When Officer Burnett got there, tell the court the conversation between you two. What did you relate to him?
I don't recall, but I mean, it's a typical standard thing for me to kind of give him the rundown and tell him what the driver had said to me, and what I observed.
Okay. And is that typical in what you would do in most stops that required a second officer or a third officer to arrive?
Correct.
Okay. And I know I asked you how long it took for Officer Burnett to arrive, but how long did the entire encounter take on your part with Mr. Lee, with the defendant?
I don't recall.
Okay. If it had taken more than, say, an hour, is that something you would have indicated in your report?
Not necessarily. I mean, if I was continuing my investigation, then it would have just been kind of what it was.
Okay. Is it accurate to say that your encounter with Mr. Lee was limited to your investigation?
Yes, correct.
Okay. And typically, how long does a stop for speeding in your experience take?
I'm gonna object to, relevance of that question, speculation of that question.
Well, I'm asking his experience, Judge.
I'll let him to answer the question, but let's keep it tailored to the relevant events here, okay?
Yeah, it really all just depends. It depends on, environment, location, the way the questioning goes. Like it just all depends on what the traffic stop is pertaining to.
Okay.
Because you can stop somebody for speeding and then end up having something completely different.
Okay, so in this particular case, were any of those factors present in terms of environment or your questioning that would have prolonged the stop past what was normal for you in stopping for such a charge?
Being on the side of 400 always kind of creates its own issues with hearing and making contact and them hearing me and me hearing them, and safely approaching the vehicle. So, I mean, depending, possibly,
Okay, and would you normally cite those things or memorialize those things?
no.
Okay. Nothing further, Judge.
All right, Mr. Watson?
Yes, Your Honor. Hey, good morning, Officer Brake. How are you?
Good morning, sir. I'm well. And yourself?
Thank you, sir. Thank you. Taking a look at your post record, it appears you took standard field sobriety, the 24-hour course. Hold on a second. That away from it. It appears you took that course in February of 2019. Does that sound accurate to you?
Yes, sir.
Okay, all right. It further appears that on May 10th, 2019, you did complete a 16-hour advanced roadside impairment driving enforcement. Do you recall that or not recall that?
Yes, sir, I do. I just didn't know the dates when they were taken.
Okay, so suffice it to say that prior to the stop on July 30th, 2020, you actually had the mandate, well, it's not even a mandate, but you had the 24-hour NHTSA field sobriety qualification course. Is that correct?
Yes, correct.
And on top of that, you had the NHTSA advanced roadside driving, impaired driving course. Is that correct?
Yes, sir.
Okay, and you certainly would agree that you were capable under Georgia law of conducting a full DUI investigation with those qualifications, correct?
Correct.
Right. And further, even there's a scientific test, right? What's the one scientific test in that battery of testing?
It's going to be horizontal gaze nystagmus.
Right. And furthermore, with that criteria being met, you were authorized to conduct the horizontal gaze nystagmus test in your investigations. Is that correct?
Correct. That's part of standardized field sobriety.
Right, right. But, right, and let's go back, Ms. Waldrip. I just want to touch on a few things. In order to pass that course, there is a actual lab component, right? A proficiency component that you have to satisfactorily complete. Is that correct?
Correct.
And that is in fact where they dose participants. They dose them with various levels of alcohol, and they require you to correctly administer all three of that battery of tests on those participants. Is that correct?
Correct.
And it is a pass fail. In other words, you can fail and people get recycled or otherwise fail that course, right?
Correct.
But obviously, if they're on your post, that means you satisfactorily completed them on those dates. Is that correct, sir?
Yes.
Okay, all right. Now, moving into the stop of this vehicle, 85 and a 65, that is why you stopped them. Is that right?
Correct.
That was the sole basis for the stop as far as a traffic or any traffic violations?
Correct.
All right, and you would going back to your NHTSA training and experience or your NHTSA training, you would agree that NHTSA does not find speed. There are 20-something indicators of possible impairment driving cues, and speeding is not one of them, correct?
I do not know that statistic as far as that goes. That is not discussed in standardized field sobriety.
Okay, all right. So you do not recall whether speeding is a cue or not that you could look for or note as impairment. Is that right?
Correct. I didn't stop him for believing he was impaired due to the speed.
Understand. And look, you can stop, right? In Georgia, you can stop for any traffic offense, right?
Correct.
You have nothing else noted in your reports or otherwise that he had any driving issues. In other words, did he pull over in a safe location, safe enough?
Correct.
Did he pull over responsibly to you?
Correct.
And use appropriate signaling or otherwise there was no problems with his changing lanes noted in your reports. Is that right?
Correct.
Okay. Now, when you start interacting with Mr. Lee, you say there was him and a passenger in the vehicle. Is that right?
Correct.
You say that you started interacting with them on the passenger side, correct?
Correct.
Okay. Now you've got two bodies in that vehicle, and you said something really important, which was that you heard they were coming from Buckhead. Is that right?
Yes.
And when you heard they were coming from Buckhead, your quote to this court was, It is a bar district. Is that right?
Yes, it is.
And so in other words, what, is it fair to say that you were suspicious at that time, perhaps had a hunch or a suspicion that these two had been consuming alcohol since they're coming from a district where that's what people do?
It's a possibility.
Okay. All right. Now on this first interaction with Mr. Lee, though, you did not note that his speech actually throughout was not noted in your report. Is that correct?
Correct.
So Ms. Waldrop asked you these questions about what you would typically note. Had there been a problem, something slurred or slow or mumbled, you would have noted that in your report, right?
Correct.
Okay, all right. He was responsive to your questions. I think Ms. Waldrop asked you that. Is that correct, sir?
Yes.
Okay, all right. And so you retreat or you otherwise go back to your vehicle, run him and his passengers information, right?
Mm-hmm.
Is that, we need
Correct.
like a yes or a no?
Correct.
Okay. And you decide to use officer discretion in issuing him a warning for the speeding. Is that right?
Yes, sir.
Okay. So you return to his vehicle. Now, do you recall Officer Davidson? Upon my review, it seems she was with you. So do you recall for certain whether she was riding with you or otherwise in a separate vehicle that evening?
She was in a separate vehicle.
Okay. Okay. That's fine. Do you recall that she was interacting likewise with Mr. Lee while you were issuing this warning? Or do you not recall?
I do not recall that.
Okay, but Officer Davidson is likewise, she was a member of the Roswell Police Department?
At the time, she was, yes.
Okay, all right. Officer Davidson did or did not relay you any other information about her interactions with Mr. Lee at that time?
I do not recall.
Okay, all right. Now, when you go back up to his vehicle, right, you go back up to Mr. Lee's vehicle, this time you make a driver's side approach.
Correct.
Is that correct? Okay. You're going to issue him this warning for speeding, and you said that you realized or I guess noticed that his eyes appeared to be bloodshot. Is that right?
Correct. Bloodshot and watery.
Bloodshot and watery. It's 3:30 in the morning, thereabouts. Is that right?
Correct.
Okay. All right. There's other there's many causes. Let's just keep it that there's many causes potentially for bloodshot and or watery eyes, right?
Correct.
Right. As far as an odor, so then you have an odor coming off or you detect an odor of alcohol from the vehicle. Is that right?
Correct.
All right. And so you re-engage him in this conversation and he tells you he's had a Corona. Is that right?
Correct. He
Okay.
admitted to drinking.
And based on that information, based on that admission, you instructed him to exit the vehicle. Is that right?
Correct.
Okay. And that was an instruction, right? In other words, he was detained at that point in time. You agree with that?
Yes.
Okay.
He's
This
detained
wasn't-
at the beginning of the stop.
Sorry?
He's detained at the beginning of the stop.
Right, but he was not. This warning that you were going to give him, that was all out the window at this point. You were further
Correct.
investigating.
Correct.
Okay, all right. And now, I don't know your recollection. Do you recall going back to your vehicle for a period of time? Do you
I
recall
don't.
going back to your vehicle?
I don't.
Do you recall radioing Officer Burnett and speaking to him in your vehicle?
I recall radioing him because it's in my report.
Okay, okay. Do you recall separate and apart from that, calling him on like a cell phone or some other device
I don't
before?
recall.
Okay, okay. And when Ms. Waldrop, asked you to kind of elaborate on this, you said that Burnett was very much into DUIs. Is that right?
Correct.
You said he wanted all he could get. That's his passion. Is that right?
Correct.
Okay. And so it seems to me as if you wanted to hand this to him, but for those reasons, right?
Because I could have arrested the defendant right then when he admitted to having a Corona for DUI less safe.
You could have or you couldn't have?
I could have. I was giving him the opportunity to have somebody else who is more trained and who has more of a passion and has more experience with DUIs to show that the defendant was not intoxicated to the point where he was less safe to drive.
Okay, and your testimony is you don't know the timeframes today. You cannot testify to the timeframes of how long we had to wait on Officer Burnett at that point?
Correct.
And you would agree that throughout whatever the time frame is, that certainly Mr. Lee here was not free to leave throughout that, right? He was in an investigative detention at that point. Is that right?
Correct.
Okay, and certainly he was compliant, I guess, would be the right word. He was compliant with those instructions, right?
Correct.
Got nothing further. Thank you, sir.
All right, any redirect, Ms. Waldrop, very briefly?
Very briefly, Judge, a few questions. Defense counsel asked you about odor coming from the vehicle. However, did you also note that there was odor coming from the defendant's breath?
Correct.
Okay. And what time did this initial stop occur of the defendant's vehicle?
Approximately 3:30 in the morning.
Okay. And do you recall what time approximately you wrote your report?
I don't.
Okay, would taking a look at your report refresh your recollection?
It would have been about 4:52. So I wrote a supplemental to Sergeant Burnett's original
Okay,
report.
so you wrote a supplemental to Sergeant Burnett's report?
Correct.
Okay, and so you wrote that, you said at about 4:52?
Correct.
Okay, so in that time frame, when you stopped the vehicle at about 3:30, by 4:52, you had already written your report or begun your report?
Correct.
Okay, and in that time frame, would the defendant have been both arrested and transported by that time?
Yes.
Okay, and were there other things that occurred once the defendant was transported back to, well, where would he have been transported
Didn't
to?
object to the relevance of this question at this point.
Please take the question, Ms. Waldrop.
So where was the defendant transported to?
Oh, he can answer that question. Go ahead, Mr. Officer Brink.
So I don't recall whether or not he subjected to the state administered chemical test, but if he did, then he would have been transported either to the hospital or to back to the station to get the breath test done.
Okay, and if he did submit to the state test, would that have taken some time as well to conduct?
Correct.
Okay. Nothing further from the state judge.
Nothing further.
All right, thank you, Officer Brink. We appreciate you being here this morning. I know it was challenging for you to get here. Thank you.
Thank you, ma'am.
All right, is there any news on Officer Burnett's report? If not, we're gonna go to closings.
Okay, I don't have anything updated, Judge, but let me just check my
All right, we'll give him
messages.
very brief moment, and then I think I've got the flavor of where we're going here.
And I don't have an update, Judge, but I can try to reach out to him if he's
See if you
needed.
can, see if you can. I was trying to pull up this State versus Jones while we were sitting here.
May I give you a hard copy, Judge?
Do you have one? That would be very helpful. That was, Westlaw is doing some interesting things up here.
Yes.
Thank you.
And Your Honor, his response, he's on the stand.
Okay,
They're in the process of the hearing right now.
okay. All right, well, let's hear our closing arguments, Mr. Watson. If you have any closing.
Yes, Your Honor, I would just respectfully submit to the court that this case falls squarely within Jones, perhaps with some added, I guess, if you want to say advantages towards Mr. Lee's position here. At least in Jones, there was some timeline that was actually admitted into evidence about what the delay was. No, I don't think a timeline, there is no time test at this point, because what Jones and the Supreme Court precedent, Rodriguez, I believe, cites to is simply whether or not there was a delay that was unreasonable. Was there delay, right? Did the officers diligently pursue an investigation, or did they not? Right. And so there is no, time testing like there has been in the past for various things here under implied consent. It's did they diligently pursue it, or did they not? Did they try to dispel their suspicions or not? And what you have here, Your Honor, is right. You don't, at most you have, the officer says he's got a suspicion because they're coming from a Buckhead area, which is notoriously known, what was his word, a bar district. But you don't have any other observations noted during this first interaction. So he's going to issue Mr. Lee a warning, right, for speeding and send him on his way. At which point he says he has some added suspicions because he smells an odor of alcohol coming from Mr. Lee. He admits to having a corona, right? And he notices his eyes appear to be bloodshot and watery in appearance, right? And so, and you know what? Perhaps the officer summed it all up right here with why this motion essentially respectfully has to be granted, because Officer Brake said, and whether I agree with that or not, Officer Brake said he could have arrested him right then and there. Okay, well, you know what? Then he should have done that, right? Because then that would have not have delayed or necessitated delay. What he chose to do, though, was continue to put Mr. Lee, keep him in this investigative detention without pursuing any further DUI investigation that he was perfectly trained and competent to do. It is undisputed in the record. Officer Brake agrees he had not only the mandate of the 24-hour sobriety training, but on top of that, he had an advanced roadside impairment detection. Your Honor, the Constitution does not have an exception for wanting to have another officer get the DUI because it's his passion. The Constitution, the reasonableness, the Fourth Amendment doesn't have an exception because someone else likes DUIs more than I do. That is not a permitted exception. There was delay here. There's delay that the state can't even establish in the record for how long the delay was. The state tried to elicit testimony of typical this, typical that. I mean, what I heard the officer say is every situation is different, dependent upon numerous conditions. But my argument doesn't hinge on what this value was. It's the simple fact that there was no diligent pursuit. And that's all of this is squarely within Jones. Jones, you had an officer that was capable, didn't do it, called for a second officer, waited, didn't pursue anything while they waited. Right. And that's the crux of this argument here. So, Your Honor, we would ask that, so when are we asking the evidence to be suppressed? Leave that to the court. But, he says he had some suspicion when he said he's coming from a bar district, right? That was some suspicion. I would ask the court to say that it should be suppressed after that because, right, or at least at the very most, when he returns back with a citation from there, when he's returned back, with a warning, that continued detention without pursuing. So we'd ask that all evidence in this case be suppressed. Thank you, Your Honor.
Thank you, Mr. Watson. Ms. Waldrop?
One moment, Judge.
Yes, ma'am.
Yes, Judge. So, Judge, here we have testimony from the officer. as to precisely why it is that he called for an officer to come out and conduct a proper DUI investigation. So I'll start with the beginning of his testimony. So he pulled the vehicle over for speeding and initially approached from the passenger side. He admittedly, did not make any indications of note in terms of a DUI. He went back to his car and was getting ready to issue a citation when he reapproached from a different side of the vehicle. Now he is at the driver's side of the vehicle. And as he is speaking with the driver, the defendant, he notices several things: bloodshot, watery eyes, the odor of an alcoholic beverage coming specifically from his breath, which he noted in his report. And he asked him where he had been coming from earlier, and they stated from Buckhead. To him, that raises a suspicion because it's a known bar district, and we are talking about 3:30 in the morning, which is the time in which he stopped the defendant. And so upon his reapproach, he asked the defendant whether he had had anything to drink, given that he was coming from a bar district at 3:30 in the morning. And Mr. Lee, the defendant, indicated he did have a Corona. So right there, you've got bloodshot, watery eyes, odor of alcohol coming from not just the vehicle, but the breath of the defendant, not the passenger, the defendant, as well as an admission to having had alcohol. So he says, well, I could have arrested him for DUI right then and there. And defense counsel asks, were they trying to dispel suspicion or not? Well, that's exactly what he testified to, that he was trying to dispel his suspicion because he wanted to do a proper and thorough investigation to determine whether or not this driver was truly DUI. And so I will turn the court's attention to the case of, give me one moment, Judge. I want to start with the continued detention and the start of that. So Woodward v. State, that's 289 Georgia App 643. That is a well-established case. I'm sure the court is aware of it. Once the purpose of a traffic stop is fulfilled, continued detention of the vehicle and its occupants is constitutional only if the officer has reasonable, articulable suspicion of other illegal activity. That's what we have in this case. He was getting ready to issue a ticket, and he discovered reasonable, articulable suspicion for a DUI. And so what he did was, to dispel his suspicion, he called out a more experienced officer who had more training than he did at the time, and who had more DUI stops and arrests at the time, more experience. He specifically said that that was the reason why he called out Officer Burnett. So you could have had an inexperienced officer conduct the DUI investigation, or you could have someone with more experience and more training, far more than he had, which is what he stated, do the investigation. Because if we had had Officer Brake do it, they would have come in and said he wasn't qualified, he wasn't experienced enough, and he would have only arrested him simply for the manifestations and not done any investigation at all. So he tried to dispel that suspicion. He tried to do a diligent investigation, which is what we all would have asked of an officer in this situation. I noted that the case defense counsel cites, the court in affirming the granting of the motion to suppress stated that at that prior hearing, the state had failed to establish why it was reasonable for the officer to detain Jones while waiting for a second unit. Here, we've established why it was reasonable. He said in his testimony, Officer Burnett had more experience and Officer Burnett had more training. That is a reasonable explanation for why you might call someone else out to do a DUI investigation. Furthermore, Judge, with respect to the timeline, this occurred in 2020. So granted, memories have faded somewhat. But what we do know is that it occurred at 3:30 in the morning. And by 4:52, Officer Brake was writing his supplemental report. And in between that time, the defendant was not only arrested, but he was transported and taken to the precinct to do the test, the field sobriety, the breath test. So that takes time. So the time from the actual stop to the arrest, we know it was no more than that hour and 20-something minutes or so, from 3:30 to 4:52. But we also know that for him to get transported back to the station and taking a breath test, that had to have taken some of that time as well. And so, Your Honor, I would submit to the court that there is clear case law that an hour and 20-something minutes is not unreasonable. And we can't even attribute the entire hour and 20 minutes to what happened out there on the roadway, because they had to get him back to the station in order to take the test. Just one moment. We also heard testimony from Officer Brake that at this time of morning in Roswell, it does not take a significant amount of time to get out to a particular area. This was 3:30 in the morning, not much traffic on the roadway. Officer Davidson heard the call out over the radio and was able to get there. And so there is nothing to indicate that Officer Burnett at the time would have been held up in traffic or some other thing that would have kept him from getting to this location in a reasonable amount of time. Just one moment, Judge. Just want to go
Take
through
your
my
time.
notes and make sure I've
Take
covered
your time.
everything.
No worries. Westlaw is not my friend today.
And so, Your Honor, given the testimony of Officer Brake, it is very clear that not only was there reasonable articulable suspicion to extend the stop after he had gathered the necessary information and was going to issue a citation. We saw that with the bloodshot, watery eyes, the odor of alcohol, and the admission to drinking. But there was more than a reasonable explanation for him to call someone else out to the scene to do a proper and a thorough investigation, someone who was more experienced and had more training. Nothing further from the state, Judge.
All right. I'm going to take this matter briefly under advisement. I'm going to ask both parties to submit a proposed order in Word for my review within 3 weeks. All right?
So how would you like me, you would like us to
Can you
submit?
send it to Ms. Smith, or you can send it? Yeah, or you can file it into the case, either one.
Yes, Your Honor.
Okay? I just want to look at one thing, and technology has failed me, or else I would have ruled today, so
Thank you,
give
Your
it some more time. Thank you all for your patience
Honor.
today.
Thank you, Your Honor. May we be excused for
Yes,
today?
may. Take care.
Thank you
Have
so
a good
much.
afternoon.
Thank you. Can I have Ms. Carter's information, the court report?
Oh, Ms. Carter? Oh, and you're not on Zoom, so you can't get it out of the chat.
No, he's not. I can give it to him if he wants to just write it down.
I've got
Yes,
you.
please.
CARTILIA CARTER, carteliacarter@gmail.com.
Thank you, Ms. Carter. I'll email you. Thank you.
Mhm.
All right, this ORCA motions calendar is now adjourned. Thank you all.